Got it. I'm on.
Oh, there we go. Ms. Perry, you are here for the appellant. Would you like to reserve any rebuttal time?
Yes, Your Honor. Please, I'd like to reserve 5 minutes for rebuttal.
You've got it. Please proceed.
Good morning, Your Honors. May it please the court. My name is Allison Perry, and I represent the appellant, who is the father in this matter, known as TT.
Ms. Perry, let me just jump out of the gate.
Jump.
I have something is curious about your argument. And what I'm about to say might seem kind of tautological at first, but I think you'll probably be able to follow it, and it won't seem so once I explain it. Your argument is that there was relief granted that was not pled or not requested. We can get to that distinction later. But doesn't that presume, isn't one of the premises that it is relief to the mother? In other words, that we have to presume that just because the father got fewer overnights, that is relief to the mother. And why I say it's tautological is because my underlying presumption is because she didn't request that, therefore we can't assume she wanted it. In other words, the mother said, here's my proposed plan, and this is how many days I think the child should have overnights with his father. And then to get to your argument, we have to assume that this is relief to the mother that wasn't pled. But how do we know that the mother wanted that?
Because that was her parenting plan. That's what she presented to the court. And she said, this is what I wanted. And you have to remember, the case law in Florida is if a court orders 50-50, what used to be called rotating custody, and it wasn't pled for, the court says, hey, you can't award rotating custody when it wasn't pled for. You have to plead for that relief. Okay,
but that's not what we're talking about. We're talking about like a marginal difference, and that's why I think my argument here is not like tautological, where there's a weakness where I say, well, she didn't ask for it, therefore it's not relief to her, therefore it's not relief that she got that she didn't request. But here, isn't it a question? It's like, well, it's just marginal, a few days here, a few days there, and because the husband got a few fewer days, it's like, oh, well, that must be relief to her, and she didn't plead it. Isn't there some wiggle room where it's not relief to one party or the other?
Well, I dispute.
You know what? The judge quibbled with both plans that were proposed and said, I think this will work better.
I dispute that it's marginal because it's twice as much time. And also the big picture is that this court, the trial court, made it clear that these, and the record, I'll just say the final judgment makes it clear that these parties were having the majority of their disputes during the parental exchanges, and that the goal of the court was to minimize the exchange.
Is that clear that was the primary goal of the court? In other words, those were fraught, whatever the exchanges, but isn't there a possibility to perceive that the court thought that the way it was doing it would have minimized the degree to which those exchanges were fraught because they would take place at different times in different places?
Yeah.
In other words, the child was well, I'm gonna let you go. I'll stop talking. Go ahead.
Well, on 405 of the record, in the final judgment, it says the court finds that the child is doing well in school, but would benefit from fewer exchanges of custody during the school days than were ordered in the temporary relief parenting plan. Now, if the judge would have taken the mother's parenting plan, there would be no parental exchanges during the school year, and the father would have the child twice as much. The child, he would have, I miscounted. I thought it was every Thursday, and it was every other Thursday that the mother requested. So it was actually 8 days out of every 4 weeks that the father would have the child, instead of only 4 overnights per week. Per every 4 weeks. So you're talking about twice as much time.
That there were other factors that the court was considering in its decision besides the reduction of the exchanges.
Well, yeah, the court considered all the 61.13 factors, but the bottom line is that he decided that both these parents were able to parent their child, and there's no reason to restrict this father's parenting to only 4 days per month during the school year.
You would agree, Ms. Perry, that the judgment that the trial court entered was fairly comprehensive and made several statutory findings about factors that favored which parent and the other, and seemed like, based upon the trial judge who was there in real time, that most of those factors either slightly or either broke even or favored the mother in some respects. So isn't this just a determination? Isn't this just a credibility slash, a parenting assessment determination that just cut against your client?
Well, the problem is that you've got to take into consideration what's in the best interest of the child.
Of course, but those findings, that's baked into the findings. That's what they are. That is what goes into that. Are those findings? You can't, pardon the term, divorce them from each other. They're inextricably intertwined. So having made those findings, where's the legal error in what the judge made? Because it seems to me that's more what you're left with here.
Well, one, the judge fashioned a parent plan that restricted the father's time sharing with the child to an extent that the mother did not even request. The mother said, hey, this is a father who she clearly did not get along with. And she said, this child should be with the father at least 8 nights out of every 4 weeks during the school year. And for some unknown reason, the court said, no, we're going to restrict his time even more. And
but when you say unknown, that's not exactly fair to the final judgment. I mean, the judgment says that the parenting plan is being entered based upon the very best interest of the child, factors that you're saying that the court failed to consider.
But the best interest of the child, the main factor, I mean, the biggest dispute that happened in between these parents happened at parental exchanges. That's undisputed. Now, how great is this? The mother came up with a plan that avoided all those confrontations, that made it.
So are you saying that the court denied the mother relief she was seeking? Or are you saying that the court granted the mother relief she didn't seek? Or are you saying both?
I'm saying both, Your Honor. And, the court had, the court does have.
So let's go back to that. You're saying, hey, the mother came up with this brilliant plan to advance or to mitigate something that she thought was, you're saying I'm reading between the lines. She thought it was bad. The court thought it was bad, which is the frequency of these exchanges. And you're saying, the trial court. So what is your legal argument if that is, considering your argument as I just presented it, that the mother came up with this brilliant plan to reduce exchanges and the trial court didn't get it? That's different than your legal argument that she got relief that wasn't pled. But in other words, it goes back to my point. Tell me why this is relief to her. Unless it's just a very black and white issue, which is like whoever gets more days got relief.
And that's exactly it. Whoever she got more days than she requested, which is relief that she was not seeking. And it was also something that the father did not know, that he was facing court, that there was a possibility that he was only going to get 4 days. Isn't
it possible that this is just a bad fit, especially given this was not a pleading issue? It wasn't as though she said, well, here's what I want 50-50 time sharing. And then she was granted, 100% custody and time sharing. This is just a proposed order. Isn't what our conversation right now showed that this is a bad fit? This argument that it was relief not sought that was granted. It's a bad fit for this scenario, which is essentially after all's been said and done, there's been pleading, there's been evidence, and the trial court just says, you know what, I've looked at both your plans and neither of them really, I think, are in the best interest of the child. I'm going to tweak both of them.
Well, I beg to differ, and I believe that she was asking for a certain plan to be enacted, and that the court erred in not adopting her plan since it decided that she was going to be the majority time sharing parent.
Ms. Perry, if a family judge ever stated on the record, I find it would be in the best interest of the child to have a parenting plan with time sharing on let's call it A. And the only proffered parenting plans were B and C. And the trial judge said, well, if I could, if only one of the parties had pled B or C, I would have, if the trial judge said, I can't enter A, which was the one that's in the best interest of the child because the parties only pled B or C, you would agree that that would be reversible error, right?
Only if B and C were not in the child's best interest.
Well, okay, so you're agreeing with me that assuming my assumption, which is that A is in the child's best interest, the judge determines it's in the best interest. You clearly disagree with this judge's determination. It's fine. But if the judge determines A is in the child's best interest, but unfortunately only B and C were the ones offered, clearly the judge can reject B or C and pick A. In fact, has to.
Yes, but
okay.
You can see in this circumstances, that's why I went on to argue that it was an abuse of discretion, because
right.
Clearly this scenario where there has to be exchanges in between the parents, which could be totally avoided by just having a couple more overnights during the school year, or a few more overnights each month during the school year, totally avoids that huge conflict for this child, which generally guarantees that this child is going to have a childhood full of conflict.
Wasn't there a countervailing interest in reducing the commute time, the frequency of the commute time for the child?
There was.
Mr. Neumeier is going to talk about that. I was just
He'll have to talk about that.
Preemptively head him off at the pass and tell me why those are so wildly weighted by the reduction of the frequency of exchanges.
Because the father was staying at his mother's house in Lutz whenever he had the child overnight during a school night. So that wasn't an issue. That he had made that a non-issue.
So he did, okay. Because he worked from home and he could work from his mother's house.
Yes. So, the thing is that this is this child's whole grown-up life. He's going to have to grow up with all these regular exchanges, which can be totally avoided by just having, a few more overnights. And it's better. This child was having a 50-50 sharing schedule with each parent and was thriving. And then all of a sudden it's reduced down to 4 nights.
Isn't there anything in the order that suggests that the trial court might not have thought that he should have spent as much time with his father?
No, it's just that these two parents.
Well, no, nothing in there. None of the accusations against the father.
Well, it's just that the father and the mother should not be spending any time together.
I think there was actual activity. There was no activity between the father and the son. That was
nothing that I know of. I'll let Mr. Neumeier say anything that he can think of, but there's nothing. It was basically that the fathers, and the mother should stay away from each other at all costs. And then you fashion a parenting plan that requires them to interact on a regular basis, which does not make sense.
Let me put it another way. Well, even if there was not, opposing counsel will clarify as he sees it, but even if there was nothing deleterious that went about the father's conduct vis-a-vis the son, was there not, on the flip side, findings that suggested that the son's time with the mother might have been perceived by the court as time better spent because of many different factors, like the mother's attentiveness to his various needs and the goings on of his life in school and otherwise?
I'm not aware of that. I would have to let Mr. Neumeier talk about that.
And that goes back to Judge Lucas's point about the various factors and how they broke for the mother in the trial court's order almost uniformly. Some were neutral,
but mainly it was about how the mother and father didn't get along and how they interacted and how their relationship.
So what's our standard of review then here? That goes back to what I'm talking about. What your main argument is, because you said mainly. Yes. So we're to say, well, mainly it was about this trial court judge. So we believe it was error that we should reverse, or is there something else?
Well, I believe it was
review besides you missed the main point, Judge.
I believe it was legal error to grant relief that wasn't requested, right, which is granting more time. And then in the alternative, I believe it was an abuse of discretion to adopt a parenting plan that requires these parents to interact when the mother had a parenting plan that was presented that
and that's where the difficulty is, because you said that goes to your point about it mainly being about reducing interaction. But an abuse of discretion standard, what would that opinion look like? Say, well, trial court, we believe that it was mainly about reducing exchanges, and therefore you abuse your discretion by factoring on all these other things and weighing them against that other purpose.
And then requiring these parents to interact after you said that they should not interact, especially when the mother had presented a parenting plan that results in the parents not having to interact.
Ms. Perry, just let you know you're into your rebuttal time now.
Okay, I'll reserve the rest of my time for rebuttal. Thank you, Your Honors.
Very good. All right, counsel.
Yes, thank you. I'd just like to point out a couple of things. Of course, in my brief, I had the difference between requesting something in a preliminary proposal versus pleading. The only pleading was for majority time sharing here. Also, the proposed parenting plan that was presented by the mother in a pretrial memo came before the former husband's, or the father, excuse me, this is a paternity case, before the father's petition for relocation, which appears to say, hey, I'm not staying at my mom's house anymore, close by to the child's school. I am now permanently relocating and want the child to come to Claremont. Of course, the biggest question is, if the mother's parenting plan was so obviously in the child's best interest, why didn't the father just accept it? Why did he choose to go to trial, which was unrecorded? Obviously, it went over an extensive period of time, and the court made extensive rulings. The point I wanted to make about the time sharing schedule is the father still gets, not every other Thursday, he gets every Thursday. It's just not overnight. So the father actually has more frequent contact. He's able to pick up from the school, drop off, and while the court did still leave some potential for parental interaction, if you look at the end of the parenting plan adopted by the court and created by the court, there are a lot of specific requirements of the parties, which could form the basis of a contempt. They're not to interact other than normal pleasantries. They're not to exchange documents. They're to be polite and respectful, and so forth and so on. So these are not just implicit, like maybe in the majority of parenting plans. These are explicit because of the problems that were caused. I would point out, yeah, there was evidently an undiagnosed anger management problem there. There was testimony and findings about where the mother credibly testified that the father had not only backed her up and choked her, but had backed up against a wall his own adult son as well. The bottom line is that, as I argued in the brief, the trial court does not face a binary selection where it has to either pick the father's parenting plan or the mother's, as the court has recognized. And in fact, there's case law that says if you just sign somebody's parenting plan and adopt it verbatim, that may be error. It doesn't look like you've done any work on your own as you're required to. This court obviously made a very, very careful determination of the facts, and then made a determination of a parenting plan, which does limit the interaction of the parties. There's now only 4 potential interactions in a 4-week period. That is the returns on Sunday night times 2, the returns on Thursday night times 2, versus the previous exchanges where the child went back and forth, repeatedly during the week.
Could you elaborate on that? You're now just making, I don't know if facts is the right word, but you're making a logistical argument undermining the mother's premise, which is that the exchanges would have been reduced under her proposed plan. And you're saying that's not even true.
That is not even true. And I addressed this probably
Well, I know it's in the briefs. We can go back to the briefs, but since we're here, and just so Ms. Perry can respond to you in rebuttal, that seems pretty fundamental to her argument. So,
yeah,
walk us through why it's not true that the exchanges would have been reduced under the mother's proposed plan. It's not about it.
Yes, there are still a number of exchanges, but the interaction is reduced because the father is permitted to pick up and drop off at the school. So the pickup on Friday would be from the school. There's no parental interaction. The drop off Sunday at 7, because the father had relocated, making overnights not feasible, would involve the exchange at the store. Likewise, Thursdays, the father is permitted to pick up from the school and drop off at 7 at the store. So there's 2, and that repeats. The following weekend would be the mom's, so there would be no Sunday exchange. And then the following week, he would have Thursday. So that's actually 3 opportunities for the parents to interact in a 2-week period. Previously, the parties had been on a 2-2-3 schedule. And there was no, I don't believe, a specific designation as to where it happened. I know that there were a number of exchanges at the store regardless. So we have in a 2-2, that would be the first 2 days, there's 2 exchanges. In the second 2 days, there's 2 exchanges. And then at the end of the weekend, there's a 3rd exchange. That's 5 exchanges every week, 10 every 2 weeks. So we've reduced the overall number of exchanges, and we've particularly reduced the number of parenting non-school unilateral drop-offs. But I would actually refer to my brief, where I spent a lot more time figuring it out instead of talking off the top of my head. But it is true that the number of actual potential interactions was both reduced and more closely regulated by the court, which is what the court indicated it was going to do. I do want to point out that, as I argued in my brief, since we don't have a transcript of the multiple final hearing days, that parenting plan by the mother could have been either explicitly withdrawn during the course of the trial. It could have even been withdrawn by stipulation. Or the father could have specifically said, I do not agree to that particular parenting plan, not just implicitly rejecting it by going to trial, but he could have explicitly rejected it, which seems likely that at trial they would have argued it is not in the best interest of the child.
Assuming the mother's argument to be meritorious that it was relief not pled or requested, the father doesn't have to accept it in order to make that argument. In other words, you talked about, criticism of trial courts for adopting wholesale one party's proposed order. But usually what happens is, the implication is, well, it should have come somewhere in the middle, not more than. In other words, you're not going to criticize someone for, the court could have come under criticism for adopting on the nose the mother's plan. But usually the point is that the expectation is it's going to be in the middle between the fathers and the mothers, but the father could still reserve the argument that, hey, she got more.
Right. In this case, it's factually distinguishable because the only reason she got more was because there's no overnights. He still gets the same number of days, except I guess you couldn't count Monday morning when he would get the child up very early in Claremont, drive the child for an hour so he could go to school. The court made findings that on those exchanges, the child was grouchy and tired all day and that both parties agreed to it. We have the argument that, hey, the father stayed at the grandmother's house. There's no finding of that. That may have been for some days, but not other days. We don't know. Clearly, that is something beyond the record. So I think that the court could well have come into court. Keep in mind, you might have a trial, theoretically, where, the parties take very limited discovery. They think they know everything. They go to trial and it comes out that one of the parties is a monster. Does that mean that the court errs by not adopting something that came about before the court and the parties had full knowledge of everything that was going on? That is why we have trials, and that's why the courts are tasked with the determination of making the best interest decision. And again, the father has basically the same number of days. The only reason he doesn't have those overnights is because he chose to move an hour away. That is the reason. He actually filed a petition for relocation, which was denied implicitly. He didn't want to have the same number of overnights. He didn't want to even have 50-50 in the Dade City area. What he wanted was majority time sharing out of Claremont with the child going to school there. That was the issue. Now he wants backsies. He's saying, well, the least I could have gotten was what the mother was proposing before I filed my petition way back, before things changed factually on the ground. And that's just not the law. It's not contract law, and it's certainly not a basis of reversal on an ultimate, very carefully crafted parenting plan. You just check and see if I have any other points I'd like to make. Oh, I do want to make the point in terms of the husband's or the father's argument that the court should, in the alternative, have issued a 50-50 time-sharing plan based on the mother's response to the petition for relocation. As I stated, that would be a prospective change, which is specifically barred in the Arthur case, where the Supreme Court tore me a new one on that one. And the father actually has wide open, if he moves closer, he can file a supplemental petition for modification, because that's what the law is. That's really all I have, unless the court has any other questions.
Are any other questions? All right, thank you.
Thank you very much.
You have 4 minutes.
Yes, Your Honors. First, I'd like to say that the exchanges are average six per every 4 weeks, because Thursday, it's four Thursdays every 4 weeks. And then it's every other weekend, so that's 2 Sundays. So these parents are having to see each other 6 times per every 4 weeks, not 4.
Are you including school drop-offs?
That's including school drop-offs. So every Thursday he picks up at school, and then they have to meet and drop off. So that's 4 every 4 weeks, because he has every Thursday. And then every other Sunday he has to drop off. So that's 2 more.
What if you don't include the school drop-offs?
No, that's not including school drop-offs.
It's not including, okay, sorry.
That's not including school drop-offs. This is just interaction with the parents. It's 6 times per week, which would be there would be 0 if you adopted the mother's parenting plan. I mean, to me, this is a clear abuse of discretion to adopt a parenting plan that requires these quarrelsome parents to interact with each other in front of this child, when it can completely be avoided. This is a unique case where the court stated its goal was to eliminate or to avoid fewer exchanges of custody during the school days. And that's at 405 on the record. And it could be simply done while giving the father more parenting time. There's as far as the father moving to Claremont, he was staying at his mother's house. That was that's in the final judgment. I was trying to find it somewhere, but if my memory serves me correctly, in the final judgment, it said when he had the child overnight, he stayed in his mother's residence in Lutz to avoid the travel for the child. So I'm pretty sure that's in the final judgment. I'm almost positive. I'm sorry I couldn't find that for you, but I'll be glad to send in a memo after oral argument to that effect if you would like. Bottom line is the father went into this thinking the least amount of time that he would get with his son would be 8 days every 4 weeks during the school year. And he left the court with only 4 days after having 50-50 custody of his child for 2 years. And the child was thriving, even though he didn't get the parents didn't get along. Florida has a long-standing presumption that it's in the children's best interest to spend as much time with each of their parents. And this court, the trial court, just adopted a parenting schedule.
Well, is the policy that they have contact with both, or would that be equal?
That they have continuously and frequent contact with each parent. And he's he would like if he moves back to Pasco County to have equal time sharing, because that's what the mother also said would be acceptable to her. So when you have a parent that says, hey, this is an acceptable parent that should be spending time with this child, and the court is saying, no, I'm going to restrict the time, I think that's an abuse of discretion. Therefore, I ask that you reverse.
All right. Thank you both.
Thank you, Your Honor.
And if you all can go ahead and exit the virtual courtroom, and we will call up the next case. The next two cases are actually related, and we have the same attorneys for the next two. I'll call the first one that's